audible? Yeah. Yeah. Thank you so much for inviting me. It's always a pleasure to come back to JNU. I've been here very often. I'm not normally in this fancy dress, but it's coming straight from court, so there was no time to change into something more fitting. Interestingly, last time I was here in this room was to discuss Professor Roy's book, and again I was coming from court, and again I was in this very uncomfortable dress. But what do you do? So I thought that. Before I perhaps explain the themes of this book, The Indian Constitution, A Conversation with Power, I'd maybe begin by explaining what triggered the writing of this book, which I think will also shed light on its major themes. The primary trigger was a well-known event on August 5th, 2019, when through two presidential orders, the special status of Jammu and Kashmir was revoked, and then through a legislation, it was transformed into a union territory. Now, in the immediate aftermath of this event, I was approached by some petitioners who wanted to file a constitutional challenge to the abrogation, which we eventually did. And we only had about 48 hours to draft and file that petition. So we had to quickly get to grips with what happened and what was done. It was a very complicated legal maneuver that was used to do that. And when I first saw what had been done by the executive, by Parliament, which effectively amounted to the governor of the state taking his own consent to authorize the abrogation of Article 370, so a lot of very dubious interpretative changes to the legal provisions, and it all seemed to me at least to be very, very clearly illegal and unconstitutional. Now that of course would not mean that the court would declare it so, because there is often a gap between what is unconstitutional and the politics that go on in the court. But it felt to me at least that if you were to honestly look at what had been done, then there was no way that you could say this was in compliance with the Indian Constitution. But then the more that I read, and this involved reading up the history of the crafting of Article 370, the political debates around that, and then 75 years of the Supreme Court of India interpreting Article 370 through multiple changes, multiple attempts by the central government acting through Parliament to progressively dilute Article 370, I became less and less sure about the clear-cut nature of this case. I still thought that it was unconstitutional, but it felt like it was a much closer case than I originally believed. And actually many of these, what seemed to be very egregious steps by the state, had over time been granted constitutional sanction on a particular reading of Article 370. So we did that and we filed the petition, and then it took a few years, as it does in the Indian Supreme Court, for it to actually get a hearing. It finally got a hearing in 3 or 4 years after the fact in 2023, where the argument that was put forward, there were many arguments put forward by the state, but the main argument that was put forward was that the goal of Article 370 was always to facilitate the integration of Jammu and Kashmir into the Union of India. And what did the word integration mean? For the state, integration meant homogeneity, or the idea that just as every other Indian state has a specific relationship with the Union or the centre, Jammu and Kashmir must also have, by and large, the same kind of relationship. So the existence of a separate Jammu and Kashmir constitution, Jammu and Kashmir's flag, all of that is antithetical to the idea of homogeneity. And so you can never have true integration without that homogeneity. And of course, the argument from our side was when we engaged with that, was actually that if you look at federal structures across the world, federalism never requires homogeneity. In fact, any diverse country, any diverse polity always understands and accepts the idea that different peoples, different societies, groups living within that nation state may in fact be justified in having different arrangements, which will actually be something that reflects the diversity of that country. So there is nothing that in federalism that requires homogeneity. In fact, the more diverse the country, the more you want a diversity in its federal arrangements. Ultimately, the court's reading of the case and its upholding of what the government did was based on the court's belief, which comes through in the judgment, that ultimately the goal of Article 370 was this idea of integration, which is that ultimately there cannot be a separate arrangement that Jammu and Kashmir has vis-a-vis the rest of all the other Indian states. So they accepted the argument of the state, and through all of this, all of this flowed from the court's reading of the entire line of cases starting in 1954 onwards, entire line of state practice and the debates in the Constituent Assembly. And so what that set me thinking about this whole process was that we have this fairly common discourse that takes place, specifically nowadays, that the Indian Constitution is, a very progressive and, I myself have argued before, transformative document, and it is liberatory, emancipatory, all of that. The problem that we are facing, is that the present government, as with governments in the past, like Indira Gandhi's government, wishes to undermine and ultimately eviscerate this constitutional arrangement. One, and B, two, that in this enterprise, the judiciary plays, either a passive or at times an actively complicit role. So there is this in popular discourse, you set the constitution on one side as this document that is basically liberatory and emancipatory, and on the other side there is the executive and the courts, which are not living up to what the constitution requires. In fact, at times they try to undermine it, and I was becoming more and more unconvinced of that position the more I worked on the Kashmir case, and the more that took me into other directions, other kinds of reading. Because it seemed to me that the court's Article 370 judgment, which of course was, an adjudication upon what the government did. So both what the court did and what the government did in 2019 did not really mark some great rupture with the past, but actually both the government's actions in abrogating Article 370 and the court's decision in upholding that action was far more of a continuum from the past than a break or a rupture. So I began to doubt this whole idea that there is a dichotomy between the constitution on the one hand and what the executive and the courts are doing on the other. And I began to explore more and more that idea, and the conceptual underpinning that I found useful was one provided by this Latin American Argentine constitutional theorist called Roberto Gargarella, who in this brilliant book called Latin American Constitutionalism 1810 to 2010, The Engine Room of the Constitution, he argues that every constitution has two parts, what he calls a dogmatic part and an organic part. The dogmatic part is your Bill of Rights, fundamental rights, right to life, liberty, equality, non-discrimination, and so on. What we often, when we think of the Indian Constitution, we think of those grand programmatic declarations of rights. That is the dogmatic part. The organic part, which he calls the engine room of the Constitution, is that part of the Constitution that creates, organizes, channels, and constrains the exercise of power. And this is, the setting up of the state, the division of power between different wings of the state, and this is the part that really, what he calls the engine room. And he says that there is a link between the two. They're not operating in silos. And he takes this example of Latin American history, where he says that after the Mexican Revolution of 1917, there was this proliferation of bills of rights in Latin America, where after every revolution, every social movement, you would have a new constitution, which would have more and more rights, greater and greater rights, expansive rights, socioeconomic rights. But what they never did, they never interrogated the way the constitution spoke to power. So you always had, on the one hand, more and more rights, but the basic power structure, which in Latin America is a presidency, which is very, very powerful, and which does not share power with other organs and bodies, that continued. And that meant that ultimately you had all these rights, but to enforce them, you came to depend upon this powerful presidential office. And of course, why would a president then care about enforcing rights? In fact, they wouldn't want to enforce these rights. And so he says that unless you accompany the expansion of rights with a democratization of the power relations that exist in the constitutional document, you really will not be able to achieve much by way of liberation, emancipation, or so on. Of course, keeping in mind that the framework of rights and the legal form itself is quite limiting. So, keeping that critique aside, within that critique, you have to work on how the constitution deals with power and what it does with the power map. So I decided to approach the Indian constitution from that perspective, to look at it from the point of view of what is the power map in the Indian constitution. How does that power map mark either a break with or a continuity with the old colonial constitutional power map? Because of course the colonial era also had its constitutional documents, it had an organization of power. And how has that power map then been interpreted over the years, decades, by the Indian Supreme Court? And of course, the Kashmir case is one example of that enterprise. And so that is effectively what the book is about. Those are the themes of the book. And so in the book, I look at 6 potential power maps, and then 2 areas of silence where the Constitution does not speak, but that itself is in its own way eloquent. The 6 power maps, are pretty straightforward. The first is the federal axis, so the center and the state, and the Constitution, of course, creates formally a federal setup, but then it reserves a large amount of power to the center, and it denudes the states of meaningful power. And over the years, the major point of conflict has been that when the Constitution is either silent or open to more than one reading, then should the court adopt a more federalizing reading, which says, okay, when in doubt, power lies with the states, or a more centralizing reading, which is that when in doubt, default to the center. That's been the major battleground over the last 75 years. So that is one axis. The second is the horizontal distribution of power within the parliament, or that is to say, the battles between parliament and the executive. So India has a parliamentary system, of course, where executive and parliament are often fused together. But parliamentary systems also have various ways in which parliament can check the executive and prevent it from becoming too powerful. So, for example, intra-party dissent within the ruling party, the opposition having certain rights in parliament, the speaker serving as the representative of the parliament to the executive and not partisan or not the a part of any political party. And of course, in bicameral systems, an upper house, where the composition of that upper house may be different from the lower house. So these are all the ways in which a parliamentary system can check the executive. And the question that I then asked is, in India, do we have those kinds of checks or not? Or if we do, how have they been understood by the courts, by the other players, by the legislature, by political parties, and so on? So that was axis number 2. The third is the Kashmir example, which is that India, of course, is a very diverse and plural nation. And over the years, right from the beginning of constitutional framing, there has been a recognition of that fact. So in the original constitution, you have Article 370. You also have the 5th and 6th schedules, which give certain specific rights of self-governance to scheduled areas. And after independence, you had various struggles and various movements. Some of it actually began as secessionist movements, as movements for independence. For example, the Naga movement. And there, in fact, to try and take the sting out of that movement, the Indian Union decided to grant special status to Nagaland, or to say Mizoram. So there was this whole push and pull where you often had armed struggle, and the only way to deal with that was then to extend or expand more rights to those areas. So how does the Constitution think of this idea that should the plurality of the Indian nation state be reflected in its constitutional arrangements, and how have the courts understood that over the years? That was number 3. Number 4 was various other institutions that are not reducible to the executive, parliament, or the courts, but perform certain very important functions of enforcing rights, creating infrastructure through which rights can be enforced. For example, election commission. You cannot have a meaningful right to vote without a functioning independent election commission. Now, some constitutions understand that and entrench such commissions in the constitutional text and guarantee their independence in the constitutional text. Not just the election commission, but a human rights commission, a gender commission, a data protection commission, and so on. So many more modern constitutions like South Africa, Kenya, and so on actually account for these bodies in the constitutional text. India does not, for reasons we can discuss or go into afterwards. So the question then is that, what does that mean for the autonomy of these bodies, which also play this crucial role in checking the executive and centralized power in any state? So that was number 4. Number 5 is rights. So rights are basically, they are the shield that the individual has against encroachment by the state. And the most basic rights in the Constitution are those that protect the individual's body and personal liberty against state encroachment. So the kinds of rights that basically ensure that we cannot be jailed, that our bodies are safe from torture and so on. There are those rights in the Constitution that are meant to protect that core sphere of the individual's bodily autonomy and liberty from state infractions. But they are framed in very ambiguous and vague language. So, for example, alone among modern constitutions, the Indian Constitution expressly authorizes detention without trial. Right? And so how have the courts understood that? Have they looked at it as an exception to be read narrowly, very, very strictly? Or have they taken it as just a part of the normal criminal justice system? So that was the 5th axis. And the 6th and final axis is the people. Because of course the preamble of the Indian Constitution begins with the phrase, we the people. But then the people go off stage. So you find no other mention of the people after the preamble. In fact, the only real role the Constitution envisages for the people is that once every 5 years you will vote, or more frequently, state elections. So you will vote for your representatives to go into parliament, and then you will retreat. There will be no further participation of the people in between elections. At least the Constitution does not envisage that. Again, this is a little different from many modern constitutions that have understood that actually periodic elections are not enough because they create a degree of alienation between the people and MPs. And the only way to bridge that gap is to have various guarantees of participation in between elections. So that was the sixth act. And as I read, we need to put it a little further away. So as I read the constitutional text, the framing debates around the Constitution, the Assembly, and the interpretation of the courts, what I found was that over the years, in fact from the inception, as a matter of constitutional design, very conscious constitutional design, the Indian Constitution has what I call a centralizing drift, which is that yes, it accounts for other kinds of power, it provides for that, but through its structure, its design, and its interpretation by courts over the years, the dominant vision has been of a steadily more centralizing understanding of what the Constitution requires. So a more central, statist, executive-based, union-based idea, homogeneous idea of power, as opposed to a more decentralized, distributed, plural, diverse vision of power. Of course, this is all contested. The Constitution, like any other document, is open to interpretation. You can. There's always contestation. It's never self-determining. But because of the way it's been drafted, its history and its interpretation, the dominant vision, subject to a few exceptions, has been centralizing. So when we think of where we stand, and when we think of the Constitution, what I argue is that we cannot reckon with where we are today by just saying, okay, Constitution good and executive overbearing, trying to demolish it, and courts not intervening. But we have to seriously and critically interrogate the Constitution itself, the choices made at the framing of the Constitution, and how those choices have brought us to where we are today. And in the final 2 chapters of the book, and I'll conclude with that, one is I talk about the silences in the Constitution. So that there are 2 major silences, and those are the economic question and the social question. So the Constitution is silent on the economic or the political economy that it envisages for the Indian state, but in that very silence it privileges one over the other. So by enshrining a fundamental right to property in the original constitution, that is now a constitutional right, for example, the constitution makes a choice. And it actually, by not actively seeking to transform property structures, it ends up enabling and entrenching the colonial property structures, and you can see that playing out in the land reform, debates that happened after independence. And then the social question. So the constitution does, of course, allow for affirmative action, reservations. It provides for the possibility of reservations, but it goes no further in addressing the social cleavages, the social hierarchies that existed in Indian society and continue to exist. So on these two very crucial questions, the constitution is marked by a silence. And then in the final chapter, which is called Yesterday's Tomorrow, based upon a very famous book of the same name, which that book traces the history of left-wing movements in 20th century and the various points in history where there could have been a different choice, but it wasn't, and then that led to closing off of certain parts like the Kronstadt rebellion and the Stalinist purges and so on. And so I look at these three moments in Indian constitutional history where other constitutional visions were put forward. In the 1920s, many princely states like Mysore put forward these very radical, decentralized constitutions with the right to recall local commune type bodies and so on, which never went anywhere. And then at independence, M.N. Roy, for example, had his own draft constitution. There was a Gandhian constitution, there was a Socialist Party constitution, and there was a type of Hindutva constitution. So there were these all four proposals, which again had some very interesting ideas of what you do with state power, and not all of them actually advocated the centralized nation state as dominant form that you should adopt. And finally, the emergency and the emergency's end was when actually there was a moment in history where there could have been a larger debate about the centralization that had taken place under the constitution in Indira Gandhi's regime, and whether it was time to rethink the constitutional design and structure that allowed for that to happen. And in part, the Janata Party rolled back some of Indira Gandhi's most egregious centralization moves, but also left large part of it intact. So that fundamental debate never happened about should we continue with this centralizing constitution even so many years after independence. Maybe there were good reasons for it when it was drafted, fears of the state holding together or not, fears of how local power structures would result in violations of rights, fears of the international domain. They may have been all valid concerns, that depending on what you think at the time of independence, but were there still concerns later on? That question was never tackled. So that then brings me to the present day, which is, of course, like I said, the thought I want to leave you with is that it is very important, I think, when we think of where we are and the power structures around us and what's happening today, to not just limit our critique to the politics of the day, but to actually ask ourselves not just how the present regime may be against the constitution, but also how the constitution in many ways enables the present regime's centralizing tendencies, and even perhaps was built for this kind of a regime to come and do what it's doing. So I would think that debate is now very important to have at this time, and I will close with that. And thank you once again for inviting me, and look forward to the discussion.